Parts 5 to 10 of the Botswana Act provide specifically for the control and investigation of restrictive agreements. In terms of prohibited conduct, the Act prohibits horizontal agreements involving practices such as price fixing, market allocation, bid rigging, restraints on production or sale, and concerted practices. The Act further prohibits vertical agreements to the extent that they involve resale price maintenance. In addition, any conduct which after investigation is determined to amount to the abuse of dominant position may be prohibited. The authority may grant an exemption from the prohibition of an agreement if it can be reasonably expected that there will be offsetting benefits. As far as investigations by the authority may initiate an investigation on its own accord or on receipt of information or a complaint where it reasonably suspects that a practice constitutes an infringement of the prohibited practices or amounts to abuse of dominance. If the authority determines that a prohibited practice has been established, it must refer the matter to the Commission within a year of the investigation being opened, or it must issue a certificate of non-referral. A complainant who receives such a certificate may refer the complaint to the Commission, subject to the rules of procedure. The Commission must provide in writing its decision, stipulating its reasons, penalties, and remedial action, and inviting the parties concerned to submit oral or written presentations. The Commission is required to give direction necessary to bring the prohibited conduct to an end. It may impose a financial penalty not exceeding 10% of the annual turnover of the enterprise concerned, up to a maximum of 3 years. Although it is not expressly stated in the Act, it would appear that the penalty would apply to the turnover in Botswana specifically. The Act provides for other penalties. A person who commits an offence, as prescribed in the relevant parts of the Act, may be liable to a fine or to imprisonment. It's becoming increasingly important for multinational firms entering the African market to comply with competition legislation in African countries, including Botswana. As economic activity continues to grow in Africa, it is expected that competition law and regulation similarly will continue to develop and become more sophisticated.